law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Come on in, folks. Come on in. Make yourselves comfortable. Welcome to this episode of the Law of Self-Defense News and Q&A show for January 28th, 2021. Welcome to all the Law of Self-Defense members checking in on their membership dashboard. Thanks, as always, for all your support. And for everybody else who may be watching on Facebook Live, thanks for joining us. If you are on Facebook, if you could help us out by commenting with your city and state, that helps provide some geographic context for us. And also click that like and share button on Facebook. That helps encourage the Facebook algorithm into sharing word of the show more broadly. And for all of you, if you like this content, then I would also ask you to do us the modest favor of simply letting friends and family know about the show so they can have an opportunity to enjoy it as well. So come on in, make yourselves comfortable. We have a packed show today. We do have to stop ourselves right at the top of the hour, but we'll get in as much content as we possibly can. We do, at the end of the show, make our best effort to answer questions that are submitted live from the live audience, either from our members or on Facebook Live. We won't review the comments for those until the end, near the end of the show, but feel free to put them in the comments anytime during the show, and expect we'll do our best to get to them before the show runs out. Now, this is the only content we produce every week that's free and open access to everybody. For the most part, our content is restricted to Law of Self-Defense members. I'll talk more about that in a moment. But we do make this news and Q&A show every Thursday, live, 4 p.m., available free. And then we also make recorded replays of it available as well. In fact, with 2021, we've launched a major effort to get ourselves on a bunch of the more popular podcasting platforms, including all of these, which I think many of you will find at least some of these familiar. Apple Podcasts, Google, Spotify. We're also on Pandora, iHeart, just about any of the major ones, even many of the minor ones. So if you like this content and would like to get it as a free podcast, just point your browser to lawofselfdefense.com/free podcast, and it'll guide you into how to accessing those. I will caution that we're new on these platforms, so the search function on these platforms often doesn't pull us up for some reason. But if you go to lawofselfdefense.com/free podcast, we'll have the specific links you need to add us to your podcast list. And of course, that's totally free. I will note that this is a different podcast than our Law of Self-Defense members only podcast. But we'll talk about that more later. Let's see. I think that's it. So let me jump into our sponsor. Make sure that they get mentioned. And our sponsor for this show is CCW Safe. They're a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal expenses if the member is involved in a use of force event. And those expenses start big and get bigger fast, folks. Imagine a case where you were threatened, you displayed your gun, you didn't fire a shot, didn't hurt anybody, but now you find yourself charged with aggravated assault with a firearm, typically a 10-year, maybe 20-year felony if convicted. And if you need to retain a lawyer for that charge, and you will, you're looking at a retainer on the order of $30,000 to $50,000, and that's just for pretrial work, folks. That's not for going to trial. If it's a killing case, where you were compelled to kill someone in self-defense and you're charged with manslaughter or murder, you're easily looking at $100,000 or $200,000 pre-trial expense. Just multiply that for the trial. So if you don't have that kind of money stuffed in your mattress, just in case you have to defend yourself, it can be useful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought. And the way you want it fought is as if your life depended on it, because really, folks, life as you know it does depend on it. And that's what CCW Safe offers to do for its members. There are several companies out there that offer similar services. I've looked at all of them, as you might imagine, and I found that CCW Safe is the best fit for me personally. I'm a member of CCW Safe. My wife, Emily, is a member. And one of the reasons I favored CCW Safe over other similar offerings is that many of those others simply don't provide the level of resources you need for an adequate legal defense. If you're looking at a quote-unquote self-defense insurance offer that caps out at $150,000 or $250,000 for criminal legal defense, that's a lot of money, folks. There's no question about it, but it's simply not enough for a murder or manslaughter trial if you've killed someone in self-defense. In contrast, CCW Safe promised to pay what the defense costs, period, with no such cap, including appeals of convictions, folks. So if you're looking at any such offering, and I encourage you to look broadly, be an informed consumer, but read the fine print, folks, and understand what you're getting for your money. I think you'll find that CCW Safe is extremely competitive in this space. Now, having said that, CCW Safe is the best fit for me. Whether they're the best fit for you is something only you can decide. But I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. Okay, so this is the Law of Self-Defense news and Q&A show. So first we start with news items that have come to my attention over the prior week involving some aspect of use of force and explore those. And then we'll jump into the Q&A section for the second half of the show. The Q&A will initially focus on questions that have been sent into us beforehand, either from our members using their member Q&A form, or anyone can send us questions for our consideration to show@lawofselfdefense.com. And once we've worked our way through the questions we've lined up for the show, I'll take a look through the comments on our membership dashboard and the Facebook Live programming and see if I can pull up some more questions to answer before the end of the show. So with respect to news, one of the news items I want to touch upon is North Dakota is setting its sights on stand your ground, becoming a stand your ground state. I know many of you will be shocked to learn that a state like North Dakota would not already be a stand your ground state, but it's not. It's a duty of retreat state. And there is a bill now working its way through the legislature to become stand your ground. That's House Bill 1193 for those who are interested. And I will embed a link to that bill in the text version of today's content. By the way, for those of you who prefer to read rather than watch or listen, we do provide a written transcript of every one of these news and Q&A shows over at the Law of Self-Defense blog. We leave these particular blog posts open access for everyone. So anytime I mention us having a link to something, that's where you would find that link over at our blog in the transcript version of today's show. So North Dakota is attempting to become a stand your ground state in the legislature. If they do become a stand your ground state, they will be the 39th stand your ground state. The media often makes it seem like stand your ground is some aberrant or minority position among the states. It's not. The large majority of states are stand your ground states. We talked last week about Arkansas becoming a stand your ground state. Arkansas would be the 38th. Assuming it becomes law, as everyone expects it will. The bill is passed the Arkansas State Senate. It's going to the House, where it's expected to easily pass, and the governor's a Republican, so will probably sign the bill. North Dakota may well be next after Arkansas, in which case we'd be left with only 11 duty-to-retreat states in America, and that's a good thing. Of course, as usual, you can count on the media to be the propaganda arm of the anti-self-defense, anti-Second Amendment crowd. They describe the North Dakota lawmakers who are advancing the Stand Your Ground bill as a group of ultra-conservative North Dakota lawmakers that would loosen the law on using deadly force in self-defense. The media writes that House Bill 1193 would allow anyone to use deadly force against an assailant without attempting to retreat from the situation. That's true as far as it goes. Of course, what they fail to mention is that for that use of deadly force against an assailant to be lawful, you still would have to be the innocent victim of an imminent deadly force, unlawful attack upon your person, and your perception of that attack would have to be that of a reasonable person. The media apparently would like the state to retain the privilege to put you in jail for the rest of your life, even if you are the innocent victim of an imminent deadly force attack, if somehow they can argue that you might have had a safe avenue of retreat. So hopefully North Dakota will join the large majority of states in becoming the 39th stand your ground state in America. Next piece I wanted to cover, and this will tie in with one of the questions that were sent in too. This is really a tragic case. A father in Texas was fatally shot when he was confronting his daughter's cyberbully. So the father was upset. The daughter had been cyberbullied over social media by, I presume, a classmate, a peer, for months, 7, 8, 9 months. And this is no joke, folks. For us adults can shrug this stuff off. For teenagers, it's really traumatic, especially when these days, and especially during COVID, when so much social interaction is virtual over social media. I have no doubt that this cyberbullying was traumatic, genuinely emotionally traumatic for the daughter. Can't have been any fun for the father either. The father decided to do something about it, went to the other party's property, went to their home, got into an argument, and got himself shot and killed in the process. He leaves behind 5 children, folks. A father of 5. No charges have been filed against the shooter yet, which of course is not definitive of whether or not the shooting was lawful or not, but it's indicative. Of course, the matter is expected to go before a grand jury. But here's the problem, folks. When the father goes to the other person's house, and he's doing it, why? He's doing it because he's upset, he's angry, his emotions are spooled up. We can't allow ourselves to get put in positions where emotions, either the other person's emotions or our own emotions, are going to get spooled up. One of the possible outcomes of such an event is dying. Maybe one's death would be lawful use of force by the other party. Maybe it wouldn't, but that doesn't matter all that much to the dead person. Also, when you go to the scene of the fight, when you go to the fight rather than the fight coming to you, it rarely looks like self-defense to anybody. We've all heard the expression, won't be none if you don't start none. You go to that fight, folks, or what this father did certainly looks like he went there prepared to fight, at least get into an argument on someone else's property, at their home. That's not a favorable form for winning a fight, either tactically or legally. There are lots of favorable legal presumptions for the property owner dealing with an apparent trespasser or intruder. And we can all imagine how the verbal interaction here probably went, right? With an angry father who loves his daughter, who he sees being traumatized for months by the cyberbully. Folks, this kind of conduct is awful. It's terrible. But what it's not is an imminent threat of unlawful violence. And until you're encountering that, the threat or use of force, or putting yourself in a situation where you may be obliged to threaten or use force, especially deadly force, is just not the smart move. Next story, New York Times article. Unfortunately, I have a link to the New York Times. Feel free not to click it. Again, there's links to all these news articles in the text version of today's content over at the Law Self-Defense blog. But in this article, it reports that the Portland mayor, Ted Wheeler, who we've all become familiar with as the guy who let Antifa burn his city down, indeed supported them in their apparent efforts, morally, if nothing else. By the way, Portland's kind of odd. The mayor also serves in this context as the police chief. So all these stand-down orders were right from Ted Wheeler. Somehow he got elected a few months ago, reelected a few months ago. So Portland, hope you're happy. You got your guy. I'm glad I don't live there. But in any case, Mayor Wheeler was apparently in a restaurant eating with a friend, and he was approached by a third party, a man who owns some kind of dairy business, and who was upset about Wheeler's, who knows, either the Antifa policies or the COVID policies, whatever the case might be. He was angry, verbalizing to Wheeler his anger at the fact that Wheeler was not wearing a mask while eating at the restaurant, was not, he claims, social distancing from his dinner companion or lunch companion. And apparently the confrontation got hot enough that Ted Wheeler, the mayor, decided to pepper spray this guy in the face. There is audio of this event. Frankly, I'm not going to play it because it's not very informative. It's rather boring, except to the extent that the man who was pepper sprayed is talking fairly normally afterwards, and that's not a bad dose of pepper spray. But it does raise the question, under what circumstances is the use of pepper spray as a defensive tool lawful and advisable? What conditions have to be met before you can use pepper spray in self-defense? And the truth is, pepper spray is a non-deadly form of self-defense. It could be used to stop an apparent, reasonably perceived threat of mere non-deadly harm, meaning almost any degree of harm. So to the extent the man who got pepper sprayed got in Wheeler's face and was conducting himself in a threatening manner, and it doesn't need to require necessarily an explicit threat. It could be demeanor, it could be clenched fists, it could be very much in personal space, and apparently this guy was within a foot of Wheeler, which is well within someone's personal space. If Wheeler can articulate that he had a reasonably perceived fear of imminent harm, virtually any degree of imminent harm, he's likely justified in using that pepper spray in self-defense. Now, Wheeler, I expect, might be a lawyer. Maybe he's read my book, but he told the police who arrived at the confrontation, quote, "I became imminently concerned for my personal safety," which are the right words, right? Now, the words themselves are not magic. There would have to be an articulation in an evidence-based way of why his imminent fear for personal safety would be a reasonable one. Of course, the standard to which you or I might be held by the Portland Police Department is probably a higher standard than we might expect the effective police chief of Portland to be held by the Portland Police Department. But nevertheless, he articulated a reasonable approximation of the legal standard. So this may well have been a perfectly lawful use of pepper spray by Mayor Wheeler, whether you like him or not, and certainly I don't think much of him. But the law ought to be the same for all of us. Another event that was in the news, a member of the law self-defense community was kind enough to send me a court order from the George Floyd case. Of course, George Floyd was the gentleman who expired while resisting lawful arrest by a number of officers. Those officers have now been charged with various forms of felony murder. And so they're all going to trial, and the preparations for trial are now taking place. And part of those preparations for trial is a lot of pretrial activity where evidence is offered. Essentially, the party, the states, and the defense attorneys for the officers have to inform each other and the court of the evidence they would like to submit during the trial itself, show to the jury. And there's a lot of evidence, of course, that's directly relevant to the events, and that's almost invariably admissible. But there's always, or often, also evidence that's more circumstantial or contextual, not necessarily related to the events themselves, but that provide a broader context to understand how or why those events occurred. So this is additional evidence that's being offered. It has to be offered for the approval of the court before it can be admitted as evidence in court. And of course, it can be contested by the other party, whatever evidence you want to offer. And this order was an announcement by the judge that essentially he's not going to allow virtually any of this evidence that either the state or the defense requested. And frankly, most of the evidence offered by the state appears really irrelevant or petty. For example, with regard to Officer Chauvin, the state wanted to offer evidence of 8 prior instances of Chauvin using various restraint techniques, presumably the same restraint technique he used on George Floyd. I guess to show that this is some kind of pattern of behavior. These 8 instances occurred over a 5-year period, which is hardly frequently, 8 times over 5 years. But frankly, I don't see the point. Even if Chauvin was using the technique every week, this knee on the neck restraint technique was taught, trained, and approved by his department at the time he used it on George Floyd. So it can't have been wrong from a legal perspective if his department trained him and approved the technique for use in precisely this type of scenario. So I don't really understand where the state thought they were going with this. And even more petty, one of the other officers is Officer Tao, I guess you would pronounce it, Thao. And they had a number, I think it was 9 or 10 pieces of additional evidence they wanted to submit against Tao. The state did. 8 of those involved all occurred in a 4-month period in 2012, April through July 2012, 7 years before the George Floyd event. So hardly proximal to the actual event. And they were all instances of Tao's FTO, his field training officer. So Tao would have been a brand new cop, basically in a probation period, under the supervision of a field training officer before he became a full-fledged police officer. And there were 8 instances in this 4-month period in which his FTO had some complaint about Tao. Frankly, given the nature of the relationship and the very short period of time in which these all occurred, this strikes me as more illustrative of some kind of personality conflict between Tao and his FTO than it does anything wrong with Tao, especially how long ago it occurred and how these complaints effectively disappeared once the FTO was no longer in the picture. So again, it seems very petty to me. There was one piece of evidence offered by the defense, however, that the judge also rejected, which I think is likely to be reversible error in this case if the judge insists on rejecting it. I think I made a slide of that particular evidentiary offering. I hope I did. I meant to. It looks like I did not. Let me see if I can pull it up very quickly for all of you to see, because it's a little lengthy and it might be more interesting to hear it rather than see it. Okay. Bear with me, folks. This is what happens when you have a live show. Talk amongst yourselves, and I'll see if I can't pull up this slide. I'm sure I can. And it looks like that worked. So here we go. Oops, and I just realized I had left myself off the screen that whole time. Sorry about that. So here is the evidence that the defense on behalf of Chauvin and presumably the other officers would like to submit so the jury can see it. And that is that evidence of Floyd's arrest by the Minneapolis Police Department on May 6, 2019, during which Floyd allegedly swallowed large quantities of controlled substances in an attempt to avoid arrest, allegedly acting in a diversionary behavior, such as crying and acting irrationally while interacting with police, and Floyd's subsequent admission to the Hennepin County Medical Center for treatment for accidental, quote-unquote, accidental drug ingestion. And of course, the implication here is that this was not accidental at all, that Floyd consumed those drugs during the arrest to avoid being caught with the drugs. I mean, Floyd was a convicted felon. It would not be good for him to be caught with drugs. And I think exclusion of that evidence is going to be reversible error, because that's precisely the narrative I expect these officers to offer in defense at trial against the felony murder charges against them. In effect, we didn't kill Floyd. Floyd killed himself by ingesting a 3 times fatal dose of fentanyl with the concurrent with our arrest of him. And that's not just speculation. Those were the toxicology results from the medical examiner. Floyd had in his blood a 3 times fatal dose of fentanyl. But it's not just in this instance. It's also, we have a prior instance, which makes this a pattern of behavior. So that's extremely relevant to the defense narrative. It offers an explanation for Floyd's death that's independent of the actions of the officers themselves. Not excessively prejudicial given Floyd's admitted history of drug addiction, prior arrest for drugs, drugs in his blood at the time he died, and of course this prior event itself. So I'm going to, in the text version of today's content, I'll embed this court order so you can read it for yourselves. It's not enormously interesting, but I like to provide the original sources for this kind of stuff. And I think that's going to be a profound mistake on the part of the trial judge to exclude that particular piece of evidence. We'll see what happens. Of course, if he excludes it and the officers get convicted, that would be a basis for them to appeal their conviction. But keep in mind, folks, an appeal of a conviction is not a do-over of the trial. At trial, all the presumptions are in your favor. You're presumed innocent until proven guilty. If you're convicted and then you have to appeal, you may have great grounds for appeal, but it's presumed that the conviction against you is legitimate. All the presumptions now run against you. It's an uphill fight all the way on an appeal. So you don't want to be at an appeal unless you couldn't get an acquittal. If you are an appeal, it's good to have good grounds for that appeal. And I think this exclusion of that particular evidence of Floyd's prior ingestion of drugs during an arrest and needed to be hospitalized as a result would be extremely helpful evidence and good grounds for an appeal if it's excluded, as so far this trial judge is doing. Another case I wanted to touch upon was not really a use of force case, but it's one of those how stupid can a criminal be cases that I just had to share it with all of you. And that is a gentleman, a drug addict, another drug addict amongst a group of drug addicts. So one drug addict killed another. The killer then chopped up the body of his victim, stuffed it into a suitcase, and left the suitcase by the side of the road. I believe this was in Boston, my old stomping grounds. Unfortunately for the killer, it was his own luggage, and he left the luggage tags from his last trip on the luggage, which, as you might imagine, greatly facilitated the ability of the police to track him down. And once they found where he lived, of course, they got a search warrant. And of course, they found a ton of blood, what the media called an excessive amount of blood, on a couch, in the bathroom, in the bathtub, and so forth. I don't know how much blood you need to see for it to be excessive, but I would expect that's not very much. On the other hand, if you've chopped up a body and stuffed it in a suitcase, I expect there'll be plenty of blood to show. The last thing I want to share with you is not so much a news item, but a good friend of mine, best friend, best man at my wedding, retired federal law enforcement agent, sent me a interesting video. I've muted the audio on this because the video's from Brazil, so we can't understand, at least I can't understand what they're saying anyway, and it's not important to the point. But what the video shows is a young man wearing a T-shirt and a baseball cap, black T-shirt. His hands are raised in a surrender type position with his hands by his shoulders. Imagine him being asked to lift his T-shirt so you can see if he has any weapons around his waist. He does that, and then we get a neat little surprise. So let me play this video for you quickly. See how this goes. So he surrender, shirts up, but look at this. What do we have here? It's a pistol that he has in a sufficient grip to actually work the action and fire the pistol. Surprise, surprise, surprise. The video is short enough that I'll see if I can share it with you again. Here's a second run of that same video. Show me, pull up your shirt. Let me see if you have any weapons. Okay, dude, you're cool. What's going on around here? Oh, look at this. Kabang, kabang, kabang. Now, a couple lessons from this, folks. One is any of you who've spent any time in competitive shooting sports will know that hands at the shoulders is not a surrender position, folks. That's a ready-to-shoot position. It's very, very quick to get your hands from your shoulders to any weapon that's around your waist. Most people who compete at a reasonably high level can present a gun from in the waistband or anywhere in the waist position, really, and discharge the first round in well under a second and a half, often under a second. So that is not a I'm unable to hurt you position. This is I'm ready to put a bullet into you in something under a second position. One of the dangers of holding people at gunpoint so the police can arrest them. Folks, the goal of any violent interaction involving a normal law-abiding citizen is to survive that interaction. If the bad guy will run away, that's a win, folks. Don't feel any obligation to hold anybody for the police. You're probably not trained to do that, and the risks are extremely high and counter to the core mission of surviving the confrontation. So don't be holding people at gunpoint unless you have no other option, is my tactical recommendation. And unfortunately, a lot of bad guys are very proficient at violence and very proficient at presenting weapons in a manner you will not like. And again, also, action tends to beat reaction. Don't put yourself in that kind of dangerous situation unless there's really no other alternative. All right, folks, those were all the news items I wanted to share with you all today. Now, of course, we cover a lot more content every week than just this news and Q&A show, so let me speak to that for just a moment. Folks who are our Law of Self-Defense members get the daily content we put out just about every day of the week, a multiple of what we offer as open access in this news and Q&A show. They get that content as blog posts or written blog posts for folks who prefer to read. Also, the forum in which we provide links to all the sources and so forth. They get all that content as video as well, and they get that content in a members-only podcast independent of this news and Q&A podcast. And of course, our goal at Law of Self-Defense is to feed you, our members, a constant stream of this law of self-defense information, insight, education, expertise. So the information remains fresh in your mind, contextual, and it's actionable for you to make better informed, more confident, more decisive decisions in self-defense, and of course also more lawful decisions in self-defense. And we do that by providing near daily content to our members. So just this past week, since the last news and Q&A show we did last Thursday, we had a post on, is it ever lawful to shoot someone in the back of the head? Can that be lawful self-defense? And in fact, there are circumstances in which shooting someone in the back of the head is not just tactically sound, but legally perfectly appropriate. Now, of course, on the surface, it looks bad. How can it be self-defense to shoot someone in the back of the head? But there are, in fact, circumstances in which that's perfectly lawful use of force. No warning need be given. The first time that person knows that they're going to be shot in the back of the head is when they get shot in the back of the head. Not at all a crime, zero legal liability, and we talk through those scenarios in that blog post. We also did a blog post on driving a car through a threatening mob. This happened to be a police officer who was involved in Tacoma, Washington, drove his car through an obstructive mob in the street. Much the same rules of engagement would apply to a non-police officer in that setting, if the same conditions were met that this police officer was facing. So it can be useful to know when that's legally appropriate and permissible for you to do. We had another blog post talking about talk about stupid criminals. They're stupid lawyers too, folks. A Tennessee lawyer who got on Facebook and actually advised a woman experiencing a difficult breakup with her boyfriend and the father of her child, so child custody issues as well. He advised her on how to make a murder look like self-defense, and he did it on Facebook. Believe it or not, he was not disbarred, but his license to practice law was suspended hard for 1 year, put on probation for 3 more years. Folks, just because someone's a lawyer or claims to be a lawyer doesn't mean you need to be taking their advice or even that they know what they're talking about. So fair warning. And then just earlier today, we had a blog post on whether it's possible under the law for an intruder into someone's home to kill that homeowner. The intruder kills the homeowner. And that could be lawful self-defense. And the fact is, believe it or not, there are circumstances in which that could be lawful self-defense. So an intruder in your home kills you in your home when you confront them, and that's lawful self-defense. If you'd like to learn more about how that could possibly be, well, that's what we provide to our Law of Self-Defense members. The great news is that membership is dirt cheap. Normal cost of membership is only about 25 or 30 cents a day, hardly breaks the bank. And you can try out membership on a trial basis for 2 weeks for just 99 cents, folks. And if you don't like it in 2 weeks, let us know you want your money back. We'll give you back not just 100% of your money, but 200% of your money. Not a fortune, 2 times 99 cents. But let's face it, you didn't pay much to try it out in the first place. As it happens, we have virtually no one who becomes a Law of Self-Defense member ever leave. And you can take advantage of that trial opportunity at lawofselfdefense.com/trial. Okay, so now let's dive into the questions that were sent into us over the course of the week. One of those had to do with Arkansas. And last week we spent some time talking about, as I mentioned earlier today, Arkansas Stand Your Ground. And someone asked, is Arkansas going to be assuming the legislation becomes law, will it be a hard stand your ground state or a soft stand your ground state? So most stand your ground states are soft stand your ground states. What that means is that you don't have a legal duty to retreat. So the prosecution can argue to the jury that they should deny you self-defense as a justification for your killing of that person because you violated a legal duty to retreat. If you're in a stand your ground state, you don't have a legal duty to retreat. So they can't make that argument. But in most stand your ground states, the soft stand your ground states, the prosecution can attack your failure to take advantage of a safe avenue of retreat from the flanks. And they do that by arguing to the jury that, ladies and gentlemen, the jury, sure, there's no legal duty to retreat, but a reasonable person in these circumstances, the circumstances this defendant found himself in, a reasonable person would have retreated. He had a path of safe retreat. And one of the requirements of self-defense is that you conduct yourself reasonably. By not taking advantage of that safe avenue of retreat, this defendant didn't violate a legal duty, but he did act unreasonably. And therefore, you should deny him self-defense because he failed to act reasonably. So it's a roundabout way of attacking you on your failure to take advantage of a purported safe avenue of retreat. Those are the soft stand your ground states that typically allow that argument. There are about half a dozen or so hard stand your ground states. The hard stand your ground states do not allow that argument. They don't allow it because they prohibit the jury from even considering the possibility of retreat in determining whether or not your use of force was reasonable. Since the jury is not allowed to consider retreat, it would be inappropriate and not permitted for the prosecution to argue about the issue of retreat in front of the jury. So the hard stand your ground states really take avoidance off the table, period. Now, I've looked at the Arkansas stand your ground legislation, and there is no hard prohibition on the prosecution referring to a possibility of retreat. It merely says there's no legal duty to retreat. So that would characterize Arkansas as a soft stand your ground state, assuming the legislation gets adopted. But more to the point, in reading the Arkansas stand your ground legislation, I noted that they have an unusual number of conditional requirements on qualifying for stand your ground. Now, when we consider the 30-something stand your ground states, about half of those are stand your ground by statute. So there was debate in the legislature and so forth. But about half of them are stand your ground by court decision, often court decisions dating back more than 100 years. California, for example, is a stand your ground state. There is no stand your ground statute in California, so don't bother looking. You won't find it. But California has case law, court decisions going back to the 1800s, making clear that there's no legal duty in California, no legal duty to retreat in California. Now, in the states that are stand your ground by court decision, it tends to be just a blanket statement. There is no legal duty to retreat if you are otherwise acting in lawful self-defense. Very simple, very straightforward, no conditions other than that you were otherwise acting in lawful self-defense, which of course you'd have to be doing to qualify for self-defense anyway. The other half, roughly half of stand your ground states that are stand your ground by statute, often in this debate process in the legislature, conditions begin to be added to stand your ground. So you don't automatically qualify for stand your ground. You continue to have a legal duty to retreat unless you meet the conditions of the stand your ground statute. And the most common ones are that you're lawfully present where you happen to be when you defend yourself. So you're not a trespasser or otherwise unlawfully present. And another common condition is that you not be engaged in unlawful activity. And that second one, of course, is an attempt to exclude stand your ground privileges from an armed robber, right? We don't want him to claim stand your ground privileges. And both of those conditions are included in the Arkansas statute. Now, I should mention the Arkansas statute was attempted a couple of years ago and failed. So this is a reattempt. And it looks like in the reattempt, they added additional conditions. And some of them are really redundant. So, for example, and they have different conditions for non-deadly force self-defense and deadly force self-defense. So for non-deadly force self-defense, the conditions are the usual ones. You have to be lawfully present wherever you are. You have to be not engaged. Well, it's more specific than not engaged in criminal activity. You have to be not engaged in criminal activity giving rise to the use of force, which would be, for example, you're committing an armed robbery. Well, that gives rise to the other party's use of defensive force against you. That would exclude you from stand your ground. But they also include not engaged in criminal activity in furtherance of gang activity. Well, I guess if you're not a member of a gang, you don't need to worry about that. But it's interesting that they decide. I have not seen that in other stand your ground statutes. Now, if a stand your ground statute has a general prohibition against being engaged in unlawful activity, well, then you don't really need something as specific as criminal activity in furtherance of gang activity. You're covered already. And then in the context of deadly force self-defense, again, the stand your ground has the usual conditions lawfully present. You have to reasonably perceive an imminent deadly force threat. Well, that's just a condition of self-defense, period, deadly force self-defense. You have to not have been the initial aggressor or provoker with intent. Again, just a normal condition of self-defense generally that you'd have to meet anyway to qualify for self-defense at all. But then they have these very specific categories of criminal activities you can't have been engaged in. You can't have been committing a gun possession felony at the time. So you can't be a felon in possession. Now, you could be a felon in possession and still have self-defense privileges, but you wouldn't have stand your ground privileges. You would have reacquired that legal duty to retreat. You can't have been engaged in, again, activity giving rise to the use of force, like a robbery. You can't have been engaged in criminal activity in furtherance of gang activity. Can't have been engaged in criminal activity in furtherance of gang activity. Presumably, you could be engaged in other criminal activity, not gun possession, not giving rise to the use of force, not involved in furtherance of gang activity, and still qualify for self-defense. For stand your ground. But anyway, I thought those very specific conditions in the Arkansas law were rather unusual. I haven't seen that degree of specificity in most other stand your ground states. Pennsylvania does have an odd one. Their stand your ground, one of the conditions of stand your ground privileges, being relieved of the otherwise existing duty to retreat, is that the person against whom you used force displayed a gun or some other form of weapon. If they didn't do that, it doesn't trigger stand your ground privileges, which is also an odd condition. Okay, so another question that came in is, last week I talked in respect to that Tennessee lawyer case where the Tennessee lawyer was advising a woman on Facebook on how to make murder look like self-defense. People asked, well, why? First of all, people were shocked that he wasn't just disbarred. Folks, it's almost impossible for an attorney to get outright disbarred. There's only one way to really guarantee you'll be disbarred, and that is if you mess with client money, you're going to get disbarred. But anything else, almost anything else, it's almost impossible to get disbarred. So the fact that his license was suspended was about as far as we could reasonably expect this to go. But people asked, well, why couldn't he be criminally prosecuted? Wasn't this conspiracy? Wasn't he conspiring with this woman to commit a murder? And the answer is that, technically speaking, almost certainly not. So conspiracy requires, the crime of conspiracy requires more than just talking about committing a crime. It requires that. So you have to be conspiring to commit a crime. But it generally also requires some overt act, some affirmative step in advancement of that crime. There has to be something beyond the talking. So you might be talking with a buddy, hopefully not you. Hopefully let's pick your drunk brother-in-law is conspiring with his buddy to rob a bank, and they're sitting around having a drunken conversation about how easy it would be to rob the bank. Not a conspiracy until they take an affirmative step. They case the bank out, they acquire the weapons, they acquire a vehicle to use, they steal license plates. Something in advancement of the actual effort beyond speech is generally required. That didn't appear to happen here. So if this lawyer had said, hey, I'll provide you with an alibi, for example, or something along those lines. I'll provide you with a weapon if you don't have one, and provides her with the weapon or makes affirmative plans to provide the weapon, mails the weapon to her, even if it's intercepted by law enforcement. Then we'd have arguably a conspiracy. Of course, she'd have to be in on it too. If she didn't know a gun was mailed, she's not participating in that affirmative step. But if she did know, if she asked for the gun to be mailed to her and then he mailed it, that would be an affirmative step. Then we'd have a criminal conspiracy to commit murder. Then we had a question come in from a platinum member. DG is the name of our platinum member. And she kind of conflates a couple separate issues. So one has to do with self-defense immunity. Self-defense immunity, many states have self-defense immunity provisions that enable you to seek a finding, a determination of whether or not your use of force was self-defense without having to go to a full-blown trial. You can do it in a pre-trial hearing. You can argue your case of self-defense before the hearing judge. And if the hearing judge accepts your argument, he can grant you immunity from prosecution or from civil suit. Much less expensive, much more time-efficient way to get a determination of legal self-defense for your use of force than the months or even years or hundreds of thousands of dollars that a trial might take. But she asks, so whose job is it what does a defendant have to do under those circumstances? Does the defendant have to produce evidence to support self-defense? And could the defense and prosecution argue over whether self-defense has been proven? And the answer is yes to all of that and more. So when you request if you want to argue self-defense at all, anywhere, pre-trial or trial, the defense has the burden of production to produce some minimal amount, at least more than zero evidence in support of each of the elements of self-defense. If they can't do that, then the use of force couldn't have been self-defense as a strictly technical legal matter. If there's zero evidence to support a required element of self-defense, it couldn't have been self-defense. There's no evidence. So you have to have more than zero evidence, not a lot, but more than zero to be able to argue self-defense at all, ever. Now, even for a pretrial immunity hearing, you would need that to credibly get the hearing. But once you're in the hearing, now typically the defense has to prove self-defense by a majority of the evidence, a preponderance. So you really have to come up with substantive evidence to present to the judge to convince him it's more likely than not that it was self-defense and therefore legally justified and not the crime that the prosecution is alleging it is. In some states, the standard's a little different. In Florida, the burden is on the state to disprove self-defense at a pretrial self-defense immunity hearing by clear and convincing evidence is the legal standard. But nevertheless, there has to be substantial evidence in support of self-defense if you're expecting to be granted immunity by that hearing judge. And fundamentally, that responsibility, of course, has to be on the defense. It's in the interest of the prosecution for that evidence not to exist in support of self-defense. Then they win the immunity hearing, right? So whatever the legal standard might be, the real burden is on the defense to produce that evidence in support of self-defense for an immunity hearing. Dee's second question, she frames it in the context of self-defense immunity again, but it's not really a self-defense immunity question. But really, it's an expert testimony question. So she asks in the context of self-defense immunity, would that be a time, the self-defense immunity hearing, for the defense to bring in expert witnesses to testify in support of the defense narrative of self-defense? And if so, do they have to meet various legal thresholds for admission of that expert testimony, that arguably perhaps scientific testimony? And can the prosecution contest those experts? Now, she mentions the Daubert challenge. Daubert was a court decision that set some legal standards for the admission of technical expert. There's an older standard called the Frye standard, also a court decision, dates all the way back to 1923. These thresholds exist because we don't want voodoo science admitted as evidence in court, right? We want whatever the expert testimony is to meet some minimal threshold of credibility. Frankly, I think the thresholds that are set are ridiculously low. It's things like the more modern Daubert standard is there peer-reviewed science on this? Many of you may not know, but I did my graduate education in science at Harvard in molecular biology and virology and immunology and lots of other hard sciences. I've read a lot of peer-reviewed papers, and I can tell you, not just me saying this, studies have been done. About half of peer-reviewed science can't be replicated, meaning it's BS. It's nonsense. So the mere fact that something's been peer-reviewed, to only a legal professional would believe that the fact that something's been peer-reviewed means that it actually has technical or scientific merit. But nevertheless, we need some kind of standards. These are the ones the courts have come up with. And the answer to Dee's question is, if you try to admit this kind of expert testimony at a self-defense immunity hearing, must it meet these thresholds, and is it subject to challenge by the state as not having met those thresholds? The answer is yes, not just in a self-defense immunity hearing, but anytime you want to introduce expert testimony, it's subject to these thresholds and subject to challenge by the state, anywhere, anytime. Now, for those of you who are interested in this, understanding the Daubert threshold, the Frye threshold standards for evidentiary standards for admission of evidence, in the text version of today's content, I will link to a very good review of these standards, very brief, but very good review, so you can learn more about the details of these if you're interested. Then we got a final question from a firearms instructor, Doug, out in Minnesota, and he asks much about a scenario much like the bullying scenario, the cyberbullying scenario I already described. If person A sends antagonizing text messages to person B to the point where person B, while carrying a gun, then confronts A and things escalate to a deadly force event, what are the consequences of A having sent that provocative email message? Well, it doesn't help B because if B is the initiator of physical force, the first person to threaten or use force, he'll lose that element of innocence and he'll lose self-defense. So he'll lose his self-defense justification. The best he can hope for then is some mitigation of what might have been a murder conviction under a doctrine like imperfect self-defense or a doctrine of voluntary manslaughter where the text message is seen as a reasonable provocation. He lost his mind, essentially, could not form the specific intent required for murder because he was so outraged by this text message. The problem with the manslaughter option is for any kind of voluntary manslaughter where you're claiming reasonable provocation, the court also considers whether or not there was a cooling off period between the provocation and your use of force. And a text message is almost certainly going to involve a cooling off period. Maybe not. I mean, you can imagine a scenario where two people are in the same bar texting each other. So they're physically proximate to each other. But most often, someone will send a mean text message from one location, the other person's in the other location. Before they're proximate, they have to close with each other. That would be a cooling off period that would diminish the voluntary manslaughter argument, the reasonable provocation argument. So the fact that B, who killed A, was provoked by a text message is not going to help him with his self-defense argument. The most he could hope for would be that mitigation. Now, what if A ends up killing B? Well, A could have a problem with his self-defense argument, even if B was the initiator of force, because the prosecutor might argue that the text was a provocation with intent. The text was intended to provoke B to launch a deadly force attack on A so that A would have an excuse to kill B. Provocation with intent is, again, a loss of that element of innocence and therefore a loss of self-defense. So that's how these kinds of communications can affect each party's claim to self-defense. All right. That's all the prepared content I had for everybody. Let me walk through. Let's see the comments from our members first. Thank you guys. Sorry I was a little late today. I looked at the wrong clock. We have a clock in the house that is a little bit slow. I've got to fix that after the show. Yeah, sorry folks, for a few minutes there I had the CCW safe slide blocking me. My bad. I just didn't see it. Steve asks, with respect to the George Floyd case, the trial judge deciding to exclude that prior event of George Floyd ingesting drugs, is that subject to interlocutory appeal? So for those who don't know, interlocutory appeal would allow for the defense to immediately appeal that decision to the higher level court, the mid-level appellate court, in effect the authority, the supervisor of the trial court. There are states that allow that. Florida frequently allows that, which is great because if there's a dispute of this source, especially an evidentiary dispute, you can get it resolved immediately before you even have to go to trial. The alternative is to go all the way through the trial, which can take months or years, and then have to appeal on that issue, which can take months or years. So much more time efficient if you can do this immediate interlocutory appeal immediately. But some appellate courts don't like it because they feel they'll become awash in appeals on every evidentiary ruling from a trial court, most of which, the truth is, won't turn out to have been very important. So unfortunately, my expertise is really use of force law across all 50 states. I'll humbly claim that as an area of expertise. But the criminal procedure law for all 50 states is beyond my knowledge. So if we have a local attorney who's proficient in the criminal defense procedure for that jurisdiction who'd care to comment on that, I'd love to hear it. But off the top of my head, I'm afraid I don't know. But that's how an interlocutory appeal would work. It would allow the defense to argue that point before the trial judge's authority, the higher level court, and perhaps get that decision overturned and be able to admit that evidence of Floyd's prior drug ingestion at trial before the jury, as they'd like to do. Okay, now that was all the members' questions. Now let me scroll through the Facebook. Thank you, everybody, for joining us. Thanks for your support. Don't forget, folks, I'm going to put this back up because this is still relatively new for us. But we do now have our podcast version of today's show, and that is you can find that at lawselfdefense.com/free podcast. Now, when you go there, it's just going to list all the various podcast providers that are hosting this news and Q&A show as a podcast. Again, it's Apple, Google, Spotify, Pandora, iHeart, lots of others. Get direct links to those if you'd like to be able to get the show as a weekly podcast. That would be the way to go. The search function may not find us. So if you go to Pandora and search Law of Self-Defense, we may or may not come up. But if you go to this URL, there'll be a specific link for each of these podcast providers that will take you to our show so you can describe. Let's see. So Ken asks, in the context of stand your ground and duty to retreat, he says, well, it's a little confusing because one of the requirements, the required elements of self-defense, is that the threat you're defending against is imminent, meaning immediately about to happen. Another element could be that you have a legal duty to retreat, but isn't it true that if you're facing an imminent threat, it would not be, by definition, safe to retreat? So you'd be relieved of that legal duty if you met the condition of imminence. And if you don't meet the condition of imminence, well, you failed that required element of self-defense, so don't you lose self-defense anyway? And that's a perfectly logical and reasonable way to look at this. What happens is in real-world use of force events, they tend to be much more murky and cloudy than we'd like to imagine. And sometimes the facts are such that the prosecution merely finds it more advantageous to argue what's essentially the same point under the umbrella of eminence or under the umbrella of stand your ground. It just depends on how he thinks he can best frame that narrative. The threat wasn't yet imminent, or you had a safe avenue of retreat. Both of those narratives may be based on exactly the same underlying facts, but the prosecutor feels one would be more compelling to the jury than the other. What stand your ground really does is take away that second narrative. Now, if he's going to argue that point, it has to be under the umbrella of eminence. This may not be how a computer would run the criminal legal system, but this is how it works with human beings. And then with conspiracy, Donnie asks on Facebook, well, if there has to be an affirmative step, does it have to be, do all the parties have to take a step or just one? I believe it's sufficient if a step is taken and the other parties are aware the step has been taken. So imagine half a dozen people decide to blow up a building with a fertilizer diesel fuel bomb. One of them says, all right, guys, that's the plan. I'll go out and get the fertilizer and diesel fuel, and he does. Assuming the others know that he's taking that affirmative step, that's a sufficient affirmative step for them all to be engaged in criminal conspiracy. But if he decided to do that independently and didn't tell them, I don't see the basis there for a criminal conspiracy. Or if half of them knew he was going to get it and he got it, and the other half didn't, the half that knew would be engaged in criminal conspiracy. The others were just talkers. All right, folks, right at the top of the hour, so it's time for me to wrap up. Thank you all again for your time. As always, I greatly appreciate it. We do the show live every Thursday. You can get the podcast version, open access, no cost, at lawselfdefense.com/free podcast. Tell your friends and family. That's the best you can do if you like this content. And until next time, just remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. My family is hard to kill. You also owe it to yourself to make sure you know the law so that you're hard to convict as well. All right, and folks, until next time, I'm Attorney Andrew Branker for Law of Self-Defense. Stay safe.